We're now going to talk about pain and suffering, which is also known as emotional distress and very closely related to loss of joy, loss of enjoyment. We're going to start with our Los Angeles Transit Lines case, where the plaintiff was dragged by a bus when the doors caught her right hand and left foot. She resulted in being disfigured, permanently crippled, had nine painful operations, and months in various hospitals for rehabilitation. The underlying claim and issue addressed by this court was torts, probably battery, possibly IIED. It didn't specify, but definitely torts because we didn't have a contract. We had a personal injury here. And the issue that is before the court is whether the jury's award of 187,000 plus was considered excessive. To determine whether this amount was excessive, we have to break down what consisted of the 187,000 plus. We had pecuniary losses, which are the losses you can measure, doctor bills, drugs and other medicines, lost earnings, and of course, future medical bills and future lost earnings because she's permanently crippled. That totaled to about $54,000 when you add it all up, according to the opinion. But the jury awarded almost $188,000. That means if you took the 188,000, almost 188,000, subtracted the pecuniary losses, that leaves us with 134,000 in just pain and suffering. And they're measuring the pain and suffering based on the disfiguration, humiliation, crippled, fear of the leg, operations, hospitals, painful skin grafting, future operations and appointments. They're pretty much dealing with all the physical pain she's going to have to deal with, as well as the mental anguish. And so now the court is trying to determine, is this 134,000 just for pain and suffering excessive? Is it too much? Well, what was the court's holding and why? In order to determine that, we have to understand the standard of review that they're using, which basically is an appellate court can interfere on the ground that a judgment is excessive, such as this jury award here, if it shocks the conscience and suggests passion, prejudice, or corruption on part of the judge or jury. However, when making this decision, the appellate court cannot weigh the evidence and pass on the credibility of the witnesses as a juror or the trial judge does, because the appellate court wasn't there. They're just reading everything through the transcript versus the jury actually heard the testimony. And the appellate court must determine every conflict in the evidence in the respondent's favor, giving him the benefit of every inference reasonably drawn from the record. So there's a lot of things that are going for the plaintiff here where the appellate court can't weigh the evidence or use the credibility. It just has to determine, does this amount 134K shock the conscience? And the issue they're actually dealing with is a step 2 issue, which is how are pain and suffering damages measured? We've determined she succeeded on the underlying tort, which is either, again, battery or IIED, but now we have to see how much she should be awarded for this pain and suffering being caused. And the court determined that there's actually no fixed or absolute standards by which an appellate court can measure in monetary terms the extent of the damages suffered by this plaintiff. So their response is, oh, well, we don't know if it's excessive right now, but there's no actual method that we can use to determine what would be appropriate for pain and suffering. And this was a controversial decision, which is why you saw a dissent, and the dissent did not agree with this standard. They actually said on page 650, paragraph 5, that pain and suffering should not exceed the part attributable to pecuniary loss, right? So the majority saying there's no fixed or absolute standards. Pain and suffering can be 4 times as much, 5 times as much. It could be only 1/4. It could be a various number of amounts. But the dissent is saying we need something a little bit more concrete. And so this is what happened in the case where you had the 54,000 and the 134,000 for pecuniary loss and pain and suffering. So the pain and suffering award was actually 2.5 times the pecuniary loss, which does not fit the dissent's rule. The dissent actually wanted to cap it at the 54K or 53K plus, right? They said that that's the most the plaintiff could receive in this particular case. The dissent also addressed this whole idea about this per diem formula that was proposed by the council and used to determine this pain and suffering amount, right? Where they said, well, let's think if she's going to live for another 34 years and we give her about 10 $100 a day, which is 660 days, or that's about $2,000 per year for 34 years remaining. They added up all these things and determined, well, this is her amount that is pain and suffering, 134K. And so the dissent actually said, well, we're capping it at a certain amount of the pecuniary loss, but we also can't use these arbitrary formulas because we can't really measure it. So the fact that the jury used this and the lower court said that this is an okay formula to determine pain and suffering was 134K was prejudicial error. This like shocks the conscience, I suppose. And so, again, this was a controversial decision. All these different jurisdictions have different ways of measuring pain and suffering. We'll summarize at the end what rule you should use, but just understand that the majority said no fixed standards. You kind of just have to check if it shocks the conscience or not using your reasonable person standard, versus the dissent wanted a more narrow rule that gave a little more guidance. And so now let's go to our second case, which is the Kish-Martin case. And what happened here, and this will give us a little bit more information about how pain and suffering is measured and awarded. But here we had parties who entered a contract to build a house for 213K. They agreed it would be built in a work-like manner. P moved in May 1992, and then the house starts leaking. The defendant tries to fix things by replacing the gutter and doing other things, but it all failed and the leaks continued for years. In the case, the jury awarded 19K in loss of enjoyment of the residence and 5K to restore the property. The appellate court affirmed the 19K of loss in enjoyment, but reduced the 5K to 3,700 plus. And so now what are the two issues before the Supreme Court? The first is whether the underlying claim is a tort or a breach of contract. And the second is whether the plaintiff can recover emotional distress for loss of enjoyment, annoyance, or discomfort in this particular case. Let's start with the underlying claim, which is the first issue. The court determined that in this case, where you have a contract to build a workmanlike structure or building and that was breached, or there was a damage to property, we have an underlying claim in both contracts and torts. And why did this even matter? Well, this mattered because it's actually a step one issue, which is determining whether compensatory damages for loss of enjoyment are even appropriate, because the rules are different depending on whether you have an underlying claim of tort or underlying claim of contract. Let's start with contract law. Under contract law, Restatement 355 is what governs most jurisdictions, where it states recovery for emotional disturbance will be excluded, which means you cannot get emotional distress or loss of enjoyment unless the breach also caused some kind of bodily harm, or the contract or the breach is such of a kind that serious emotional disturbance was particularly likely to result. And it's a little bit different than tort because contract doesn't always involve some sort of physical injury or property damage, versus for tort, it's easier to prove and not necessarily measure, but prove that some emotional distress happened. Whereas in contracts, it's a lot harder because it's more just like a business transaction. But we do have the minority version that says the breaching party must bear the full burden of the harm caused, and there should be no exception for emotional distress damages. So they're pretty much saying, well, no, we shouldn't cap it to only bodily harm, or serious disturbance would likely result from the breach. Like, we want to keep it more open-ended. Again, courts differ, but we're going to stick with the restatement for purposes of our class for the main rule. But I wanted to pause real quick and address the terminology that we're using, because we have the words loss of enjoyment and emotional disturbance here. And we have emotional distress, pain and suffering, loss of joy. How do these all relate to each other? Well, these are all considered types of emotional harm. Emotional distress is essentially the same as pain and suffering. And loss of enjoyment is the same as loss of joy. And emotional distress, pain, and suffering is pretty much like loss of enjoyment and loss of joy. What actually constitutes loss of joy and enjoyment, according to the book, is non-pecuniary loss of the capacity where the value of a person's life is lowered. What constitutes emotional distress and pain and suffering is suffering from physical pain and mental anguish. So all the jurisdictions are trying to determine, well, is loss of joy an element of emotional distress or pain and suffering, or is it a separate injury? Because physical pain and mental anguish lowers the value of a person's life, lowers their joy and enjoyment. The answer is they're all essentially the same. Can a plaintiff recover both emotional distress slash pain and suffering and loss of enjoyment and loss of joy? It's more likely no, because they're too interconnected. And remember, our actual general rule is plaintiff's damages are limited to its actual loss to ensure the plaintiff does not get a windfall. And so here, if you're trying to claim mental anguish under emotional distress, and it's the same mental anguish you're trying to claim under loss of enjoyment, it would end up being a windfall. Now let's return back to our case and deal with the second underlying claim, which is tort. In torts, a plaintiff must consciously endure the suffering or have some level of awareness to recover emotional distress. And that's why we slot it more in the tort section in our chart, because pain and suffering tends to come more often with torts. Even though it's available in contracts, it's available in a very limited capacity. Now, the second issue that the court addressed was whether the plaintiff can recover emotional distress for loss of enjoyment, annoyance, or discomfort. And as we discussed, they determined yes, emotional distress is available. But in this case, they reversed the award of $19K for loss of enjoyment of their residence. In the opinion, it said even though the award arise from a tort claim, it must be reversed. It didn't really give us any explanation, but it did explain that it's not possible for the plaintiff to establish the damages under Restatement 353, which is to show the bodily harm or show that this is the type of breach that would cause emotional harm. Your house leaking doesn't necessarily cause loss of enjoyment or emotional distress in that way, according to the court. Are there other situations where emotional distress, pain and suffering, loss of enjoyment are available other than the three we talked about today? The answer is yes, there's a lot, and it varies by jurisdiction. It varies sometimes within jurisdiction, because even the book says, in short, this area of law, emotional distress, pain and suffering, loss of joy and enjoyment, it's an utter mess. Everything overlaps with each other. There's no clear rule. There's no fixed and absolute standards. It just depends on the judge at the time. It's really squishy. For purposes of the exam, this is what I want you to use. We bunch it all together like we talked about, right? It's one type of injury. Are compensatory damages appropriate? Well, under contracts, yes, we use the majority rule, right? Which is cause bodily harm or the contract or breach is the kind that would cause serious emotional disturbance. There's also the minority rule, which is yes, it's allowed no matter what. And then you have torts, which is the conscious enduring or some level of awareness, right? So they need to suffer some sort of physical pain or some sort of mental anguish. Those are the two categories to think about: physical pain, mental anguish. Step number 2, how is pain and suffering measured? Well, the majority is there are no fixed or absolute standards, right, where we can measure it. But we do want to look at the dissent that says, well, we can't exceed the part attributable to pecuniary loss, and we can't use the per diem formula. But there's one step 3 when we're dealing with pain and suffering, which is this whole issue of whether the award is excessive. And that's where we apply the standard of review, which is it can't shock the conscience or suggest passion, prejudice, or corruption. And the appellate court can't weigh the evidence or credibility and must determine the conflict in favor of the respondent. And the last thing I want to add is if we determine that the award was incorrect, what can the court do? And this is very practical. This is what happens in practice. Well, the court can issue a remittitor, which lowers the amount of damages granted by the jury, or a motion can be made to ask to lower the damages. Or if it's too low, the judge can increase the amount granted by the jury from additor, even though the plaintiff doesn't have to consent, at least the defendant needs to, because we're asking the defendant to pay more. And this is not allowed in federal courts, but some state courts allow it. But more commonly, they just remand, send it back to the lower court, have it retried according to their decision, or recalculated.